Welcome back to Inside the Court, where real drama unfolds without a script. Today's case? A defendant, Ms. Johnson, standing before the judge for sentencing. But there's a twist. She hasn't completed her alcohol screening, she's missed a scheduled test, and probation is not impressed. The judge already warned her months ago about missing anything, and today, patience is wearing thin. Her attorney is pushing hard for more time, arguing she has a steady job and can't afford jail time, but the judge's tone says it all. This isn't going to be an easy sell. What would you do in her shoes? Try to delay sentencing or face the consequences head on? Let's find out.
Today's the date and time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing order.
Why?
Why what?
Why'd you miss a test?
This is the moment where everything starts to turn against Ms. Johnson. The judge is reminding her, in no uncertain terms, that back in April, she was given a break. All she had to do was not miss tests and finish her alcohol assessment. That's it. But here we are, months later, and neither has been done. For those of you wondering, the alcohol screening and assessment is not optional. It's a formal evaluation used in sentencing for DUI or alcohol-related offenses, and failing to do it can severely limit your options. Without that assessment, the judge can only go by the maximum penalties. That's a dangerous position to be in, and right now, Ms. Johnson is skating on thin ice.
I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh. They do so much. I didn't send you the last time. I'll re-refer to defendant to Von Schwartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening assessment, the only thing that I can really sentence you to is the maximum time. And I don't want
The
to.
paper,
What?
the paper,
What?
all the lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
Is that somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced at August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that.
And here it is, the breaking point. After hearing excuse after excuse, the judge makes it clear. If she can't follow these orders, the only path left is maximum jail time. And remember, this isn't just about one missed appointment. It's about a pattern of non-compliance. Judges look at behavior, not just the incident. Then, without much hesitation, the hammer drops. 3 days in county jail for a bond violation. You can hear the father in the background trying to intervene, hoping to keep her out of jail. But in a courtroom, a judge's patience is like a ticking clock, and hers just ran out. If this were you, would you think the judge was too harsh or just doing their job?
I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant remanded. Just go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up to the, can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know. And I trust me, I did not want to. I just, Miss Polera, can you give to Dad the Von Schwartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
And is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
Whose case is this? Yours?
So, what did we learn from this tense courtroom exchange? Compliance is everything. Ms. Johnson had months to finish her alcohol screening and maintain her testing. But when those orders aren't followed, even sympathetic judges are left with no choice but to act. The father's plea showed genuine support, even offering to pay fees on the spot. But in the end, the judge needed to send a message about following the court's directions. This case is a textbook example of how small missed steps can lead to major consequences in the legal system. If you found this breakdown as eye-opening as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe to Inside the Court for more real-life legal showdowns.
Yes, Your Honor.
Counsel approach with Ms. Blair.
Good morning.